Our last report on consumer protection. Jim Carter has the story.
Small claims court is the simplest and most inexpensive means by which a consumer can seek legal restitution in a minor dispute with a business or an individual. The idea is that for a very small fee, $10 or so, you can go into court and present the facts of your case yourself before a judge who decides the case.
I want you to fill these forms out. This is your summons. You'll be the plaintiff in the case, and the person you're suing is the defendant.
The process begins in the circuit clerk's office at the Jefferson County Courthouse. Here you fill out forms, briefly explaining what your complaint is, who it is against, and what money or compensation you are seeking. For a case to qualify for small claims court, it cannot involve more than $500.
All right, we're not lawyers, so we can't, get involved in anything legal, but the forms are very simple, and we show them the form, how to fill it out, and what is required.
And when people come in, are they apprehensive about not doing well and presenting their case well?
Yes, and we try to assure them that, everybody's that way, and it's just the average, person that can do it. It's very simple. You go before our court, you just present your facts, and that's it.
How much will the judge help the individual in the courtroom?
In the courtroom, and I'm assuming now that that neither party has an attorney. The plaintiff's looking at me, and he says, well, Judge, what do I say? The defendant's looking at me, saying, if you tell him what to say, I'll shoot you. And so the defendant gets up, and I have helped the plaintiff. Am I going to help the defendant? I'm supposed to be impartial. I'm not supposed to take the side, either person's side. We will try to make sure before we start the trial that they are ready for trial. That is, we'll ask them, do you have all your witnesses here? Do you have your evidence here? But once the trial starts, it's just as whether they have an attorney or don't have an attorney, we cannot help either side.
Last January, Bill Turner was involved in an automobile accident that was the fault of another driver. Because Turner was driving a 1966 Rambler, the other party refused to pay the $300 damage estimate, so Turner took the matter to small claims court.
Well, I took the bill of sale and all the estimates I could find for this car, and anything else that I felt would show the value of the car, and went down there in my good suit and sat down there like nervous, and just presented my evidence, told the judge what happened. He asked the questions, and I answered them, and then I was to step down and let the other fella get up there, and he did the same thing, and he just came, as far as I can tell, sort of unprepared. He didn't have anything with him except his word, so the judge considered both sides and said that he felt that I wasn't asking anything unreasonable.
Small claims court may seem like a very simple answer to some irritating problems, and it can be, except for one drawback. The person who wins the case is responsible for collecting the money he is awarded by the court. And how tough is collecting?
Too many people think that because a judgment's been rendered, the defendant's going to run in and pay that judgment. That is not true. Most defendants, and, well, matters are small, don't even bother to appeal. If they don't even bother to appear to contest the claim, they certainly aren't going to hurry in to pay a claim.
Consumer protection, unfortunately, is not a simple matter. It requires specific laws, strong enforcement, as well as sufficient penalties for violations. But most of those we talked to agreed that the consumer is his own best protection. As one state official put it, 90% of all consumer problems could be avoided if people would check before they buy and just use common sense. Jim Carter, Newswatch 13.